Hello, hello, and welcome to the Listen to This Bull live show. My name is Matt Mulholland. That is Remington Huggins. He hasn't been in that chair in several weeks. The chair got really cold when you sat down in it. Did you feel your butt's indentation still, or was it gone already?
It was gone, man. It was like a pillow I haven't used in 4 years. You know, it's kind of upsetting. I was jumping around,
flipping the mattress around. Yeah, that's pretty cool.
Exactly.
This is the show that you get to ask us questions about bullshit in the insurance world, and you do so by writing commentary. And if it's a good enough question, we have time to answer it. We'll pull it up onto the screen and try to get your questions answered. We have a guest today with a fairly large name. Steve Badger, Mr. Defense Counsel himself, is here, waiting in the wings. As soon as I get through with our intro, I'm going to pull him on. Hey, Steve.
Yeah, I didn't have time to read the disclaimer, guys.
Yeah, no, I moved it off immediately for that reason. You can pause it later and freak out. That's fine.
All right. Now I'm
welcome on, Steve.
So you work for a company named Zell. Is that your company, or?
I am one of the senior partners in the law firm. We've got about 100 lawyers nationwide and in London, and there's about 20 of us who are the senior equity partners. So is it my law firm? Well, I am a co-owner of the partnership.
Gotcha. Do they call you Mr. Defense Counsel over there?
I have lots of different names depending upon who you're talking to, but all of my attorneys just call me Badge. That is my nickname. So okay. I don't know Mr. Badger, none of that crap. I am simply just Badge.
Love it. Matters what day of the week it is, Matt. You know.
Okay. Is it cool if I call you Steve?
Steve is good. Yes,
Steve is good. Is what your wife probably says. Steve is good. Steve is good. So you are a defense counselor, and today we're talking about appraisal. I wanted to have this conversation with you because I became aware of some new appraisal language that you are posing as an option for the clients that you work for. Can you tell us a little bit about it?
Sure. You know, when I was a young lawyer doing this work, there were very few appraisals. We maybe had 1 or 2 appraisals in the office, but they were always in a complex fire claim or an explosion claim. So we didn't have a lot of appraisal matters in the office. But as all you know that in the past few years, appraisal has taken off. And I've got 28 lawyers in my Dallas office working on basically hail and wind, other catastrophe claims. And about maybe a third to half of their dockets now involve appraisal. And it's just an unbelievable explosion of appraisal matters that we've seen. And obviously, as a result of that, the widespread use of appraisal, there are a lot of issues now. There are abuses of the appraisal process. There's uncertainty in the appraisal process. So as a result, like any issue that arises in the insurance industry, when problems arise or issues come up, the insurance industry reacts by changing policy forms. That's just the reality. They control the policy forms. They get to do that. So our clients have come to us and asked us to help correct some of the problems, including abuses, that we're seeing in the appraisal process. So I have drafted a revised appraisal clause that we're giving to our clients that we believe addresses, and we believe fairly, all of the abuses and uncertainties that we're dealing with in the appraisal process. So that's what we've done. Some of our clients have taken it wholesale and they're using it completely. Others have taken certain components that they like. If they're an admitted insurance company, they have to get it approved by the state Department of Insurance before they can use it. Some insurance companies that are called surplus lines insurers, they have what's called form freedom. They can just add a new endorsement or change the language every day. They're just putting it in their policies. So that's what we've done. We're trying to preserve the use of the appraisal process and make it fair for everybody.
Do you know, or why do you think that there are so many appraisals these days versus 20 years ago?
Yeah, because there's so many more claims in the hail and wind area than there was 20 years ago. This whole area has just exploded exponentially in what we see in this claims area. And we could talk about why that is, but that'd be a whole nother show. But that's what's happened. So there's so many more claims, and I think a lot of people see appraisal as a quicker, easier, less expensive way to resolve claims, and that's why it's there, right? It's a non-judicial dispute resolution process intended to resolve claims quickly for the benefit of both the policyholder and the insurance company. Now, we could talk about why some people are using it, and in my view, abusing it, because it's non-judicial. There's no ethical guidelines. There's no rules of procedure. So it's a hell of a lot easier to submit an inflated estimate and manipulate the process when there's no man in a black robe who is going to keep an eye on your conduct. So I think that's...
It was originally designed to be as fair as possible. You've got a representative for both sides choosing an umpire together. Mm-hmm. So doesn't that force a fair interaction?
Not when the appraiser or lawyer for the policyholder runs down to the courthouse without giving notice to the insurance company and gets their favorite buddy appointed as the umpire without telling us that they're going to get an umpire. So that's just one example, which everyone knows one of my big pet peeves is the unilateral umpire appointment. So there are things like that are done to disrupt the fairness that you're talking about. Yeah, so if both sides worked fairly to try to reach agreement on an umpire, and if they're unable to, they work cooperatively to go to a court to get an umpire appointment. In theory, yeah, it should be a fair process because we should have a fair neutral to listen to the two sides and come up with a fair solution.
I mean, most people that have done appraisal in the past know that the umpire selection itself is probably the most important aspect of an appraisal. That is what makes or breaks the appraisal for your client. So often opposing appraisals have refused to even attempt to contact appraisers on our appraiser or umpire lists. Umpires on our umpire lists. And just say, nope, we disagree with all these. You have to choose one of ours, or we'll go to court and get one assigned. It becomes almost a political process to try to work with the opposing appraiser to come up with an umpire. There's strategies built around these models. It's not in itself a fair system, just choosing an umpire. Do you have any ideas on how that could be fixed or improved?
Yeah, so the scenario you're talking about, I see it also regularly from the other side, right? So it's the same thing happens. My client's appraiser will submit 3 names they believe are reasonable, and the opposing appraiser will look at them and say, nope, they're all insurance company whores. I'm not using them. All right. So the first thing I would suggest is that both sides stop picking people that they know the other side's going to object to. All right, let's actually try to find the people who sit in the middle and are fair. And let's go to that process as opposed to putting our 3 people that we like on each side, going to the court and hoping the court goes eeny, meeny, miny, mo and picks our guy, because that's what you're talking about. That's the heart of it, is that the umpire selection is the key. So that's unfortunate. That's not what it was intended to be. So in most of our matters now, whenever we go to a court for an umpire appointment, when we're asked to get involved and ask for an umpire to be appointed, we will tell the court, don't choose a module list. Just pick someone that you believe is fair. Pick a mediator, pick a retired judge, pick somebody you know who will look at the facts and reach a fair result. Because that's all we want is a fair result. That's why appraisal's there.
Matt, I want to add this, that I would say in the last 18 months of me practicing, I have filed more having the court to intervene to get an umpire appointed than probably the last 5 years. Like it's been a madhouse of me having to get umpires appointed. And I have to say this, I feel like now, like some of these appraisers, and look, we need appraisers, obviously. So, but I think some of it is ego gets in the way between these two appraisers, one for the carrier, one for the policyholder. And these guys have gone against each other in the past. So they have some history, and not one of them wants to agree to the other one's umpire. So now we got to go to the courthouse and get them involved. And I think that ego is now preventing these claims from getting resolved quicker than they should. We shouldn't have to go run to the courthouse to get an umpire appointed every single time now. Like it's gotten ridiculous. And in fact, yesterday I got an order from the court that told me and opposing counsel, your appraisers need to be adults and they need to go figure this out. We're not going to appoint anybody because we're not bound by the terms of the insurance policy. So you guys go figure it out. I thought that was kind of funny, kind of cool, actually. So something different.
That is different.
Well, there are strategies where, each appraiser point or names 3, and the other side other appraiser gets to just strike 2, and the other 2 are put in a hat, and you choose, one of them. I mean, there's things that they could do to get creative to avoid having to go to the court.
That sounds very risky. It becomes
it's risky. It's risky if each side is putting 3 people up who they know are going to rule for them. Right, that's the problem.
Sure. Right,
yeah.
right.
But if
that is the abuse.
That are reasonable. Man, look, yeah. I put up on a regular basis. I'm putting up public adjusters and contractors, people who are from the other side, but I know them to be fair.
Sure.
And so I have no problem with that. Now, are there some on the other side who I would never put up because I know they're going to screw over my client? Of course, just like from the other side. Right. And there are some people on my side who I know that the other side just despises. Yeah.
Do you think that defense counsel should be allowed to provide an umpire list to your appraiser?
I have no problem with counsel from either side providing recommendations of umpires. I have no problem with that. What we cannot do is dictate who they put up. I would not do that. But if I have recommended umpire names who I would suggest to an appraiser, sure. Right. I have no problem with that. But I would, it's wrong for either side.
Are recommended.
And people can be a skeptic of it, right? Yeah. I get that.
Well, it's on both sides. Conversely, should a public adjuster be allowed to give the appraiser that they have chosen a list of umpires to use?
And that's fine.
I think the answer is the same in both cases.
A list to recommend. These are some recommended people, but you cannot dictate.
And for the record, for plaintiffs' counsels out there, I agree 100% with Steve on that. 100%. I don't see any issues with it.
I think that just even if there's nothing specifically diabolical about handing a list over, it invites the opportunity to be inappropriate and push somebody towards something. Being removed completely from that process, it's supposed to be a third party process that's being run by disinterested individuals. But there's definitely nothing on the books that says anything other than what you are suggesting anyway. So it's just opinions at that point. I've got a few questions I'm going to post up. Javier was asking, what do you mean by abuse? What are common abuses of the appraisal process? So you discussed the umpire situation. What else would there be?
Okay, so I got all kinds of them. I could list a bunch. And I recognize that there's beliefs that they happen on both sides, but I will tell you some of the ones that I see that really bother me from the insurance company side. Again, I'll mention again because I believe it's so important, is unilateral umpire appointment. All right, no one should do it on neither side. It's just wrong. All right, man up and be honest and work together with the other side to get an umpire appointment. That is just There is no role for unilateral umpire appointments. That's number one. Number two is the sandbagging and adding new claim components to appraisal for the first time, or to the claim for the first time in appraisal. So we've got a nice roof dispute, and we say, okay, we're fighting about whether the roof has to be replaced. It goes up in appraisal, and then all of a sudden now the appraiser adds the windows, the siding, the barbecue, and the trampoline. All right.
I want to pause you on that point. That was something I definitely wanted to get into this conversation. For you, you just said sandbagging, but in the past you have called that differences of scope, where someone is presenting damages that were never claimed as a part of the appraisal process. But the terminology that you've used in the past, calling it scope, has caused some conflict in other jurisdictions, in other courts, where they're meaning something else. So if you're okay with it, I'd like to start talking about scope. I'm going to lay down a little bit of background, though.
Sure.
The term scope, whether we're talking about scope of coverages, scope of damages, scope of repairs, or mouthwash, this term really isn't clearly identified in a lot of court cases. And this is being tried across the U.S. It seems to be pushed mostly by State Farm, but I'm sure there might be others. But they're challenging whether or not amount of loss includes differences of scope. Whether or not amount of loss, it can only be a dollar difference on an agreed to scope. In several states, Georgia being one of them, and possibly the first state that has done this, the scope was removed from amount of loss. And in effect, if we have two separate estimates and one of them has a line item that the other one doesn't have, that's considered to be a difference of scope, and it isn't appraisable in Georgia. So one line item difference is a difference of scope, even if it pertains to the same roof. If we're talking about stuff that's non-claimed, damages that are non-claimed, that's scope of damages. If we're talking about roof damages, that's scope of damages. But are we talking about scope of repairs sometimes? When you get into the word scope, and when a lot of courts get into scope, they even start mixing those terms. They'll say scope of repairs possibly, or scope of damages in the same breath, and talking about the same thing when those can very easily be different things depending on who you're talking to. That terminology is so ambiguous in itself. It can be interpreted so many different ways. Scope of damages to an insurance policy may very well include scope of repairs, because damages would include anything that's happening as a result of that same cause of loss. But when you ask somebody what they would think, a layman, it would mean something else. When you say scope and you're talking about different damages that were not claimed, completely separated, is there a line? And should we start clarifying that?
So two different issues here. So let's set aside my pet peeve issue about new claim components in appraisal. All right, and then let's go back to the core issue of what is the scope of appraisal. All right, what do we appraise? And just 30 seconds of history. Forever, as you talked about, forever appraisal only addressed a dispute as to the cost to repair an agreed amount of damage, right? We all agreed the roof was totaled. All we were fighting about was what it was going to cost to replace that roof. That was the limit of appraisal. And Texas was very clear on this, as were most states. There was an old case called Wells, and appraisal was limited. But then in 2009, the Texas Supreme Court issued a decision in State Farm versus Johnson in a Hale case and said, this appraisal thing's pretty cool. We can keep cases out of litigation. So let's allow appraisal to include disputes as to the scope of damage. And then other states started adopting the same State Farm versus Johnson approach and widened the number of matters that appraisal could address. So now we have a situation as to uncertainty as to what, as you say, what is scope? All right. So there is this slippery slope of uncertainty as to what we actually can appraise. Now, just a couple of years ago, the Texas Supreme Court issued another decision in Barber Technologies that said you do not appraise causation or coverage. Very clear. Court said that. Don't appraise causation or coverage. All right, so wait a minute. If we can't appraise causation or coverage, then how do you appraise hail disputes where you're fighting about whether the roof is damaged or not by hail, or whether it's wear and tear, or when it occurred, all the normal issues. So there is horrible uncertainty right now under the law of my state, and I think a lot of states, as to what matters are properly appraisable. If we're fighting about whether the roof is damaged and has to be replaced or can be repaired, is that appraisable? I know you alluded to State Farm, and I'm hearing a lot of calls. I don't represent State Farm, but I'm getting a lot of calls from people on your side saying, wait a minute, State Farm is refusing to pay any awards when there's a dispute as to the existence or extent of damage. And I suspect what State Farm may be doing is just saying, we've got to get clarity here, and we're going to get this up to the courts and clean this up. I don't know that, but I'm just speculating as they're seeing so many. So we have to get clarity as to what we're appraising. I agree.
Can I, when you think of coverages, this is a very simplistic question that seems like it would be an easy answer, and it isn't. When you think of coverages, do you think individual items or individual coverages?
Yeah, so there are some who will take the position that whether that roof is damaged or not is a coverage question, because our policies provide coverage for physical loss or damage. All right, those are the key words. So if you're fighting over whether or not the roof has suffered physical loss or damage, there is an argument to be made that that is a coverage question. All right, now that is a legitimate argument to make. What's my preference? My preference is we go into an appraisal with an agreement, right? Because remember, appraisal is a creature of contract. It only exists because the two parties to the contract, the insurance policy, have agreed to go to appraisal. Nothing prevents those two parties at the beginning of appraisal to say, hey, let's agree so we can get a clear award that we are going to appraise whether the roof was damaged by hail, and we're all going to be bound by the outcome. We can do that.
You could have an appraisal memo in the beginning to do that kind of thing.
Whenever I put forward an appraisal protocol, everybody on the other side, Badger's trying to trick us, right? No, I'm not. I want clarity so I know that the appraisal is the end of the process and not the beginning.
I'm with you, 100%. Clarity is really what a lot of us, I think, are looking for, and the terms that are being used are ambiguous, which is why we're digging into these. Let me clarify what my question was, though, because I don't think that you're dealing with this so much in Texas, probably. I've got two personal property items. I've got a mouse and I've got a cell phone. Both of them are damaged in a water loss. Are these individually their own coverages? Or is this coverage C?
I'm not sure what your question is. I'm not a very smart
If coverage C is opened because they're paying for this cell phone that was damaged in the water loss, but they're not paying for this mouse, but they've opened coverage C, is the scope of coverage C, or is the scope of coverage this phone and this mouse separately?
Well, you have to evaluate every damage component separately. You just have to. You have to look at what caused that damage component or what damage to that component. I may be on a roof and I'm looking at hail damage to the roof, but the air conditioning unit's not working because it's been out of order because someone stole the copper 5 years ago. So I will have to evaluate each component individually.
All right, then that leads to the real question. If you've got individual components that are shingles and we agree this one's damaged, but this one is only going to be damaged when the roof is replaced because you can't replace this one without damaging the rest of it. Is this a difference of scope or a difference of coverage?
Yeah, so under Texas law, all right, you're talking about a scenario that was addressed in the All Saints decision maybe 15 years ago, where the court held that under Texas law, all the insurance company owes is the cost to repair the damaged shingle and not the undamaged shingle that could not be repaired because it was falling apart when they fixed the shingle next to it. But all the insurance company owes is coverage for the damaged shingle. And that's because we have something in Texas called concurrent causation. And we'd have to get into this issue about whether it's...
If we were talking about direct physical loss, is it not true that direct physical loss would include anything that would occur as a result of the repairs of that loss as well, as a part of the reasonable and necessary cost to replace?
Not under Texas law. That's the concurrent causation doctrine. Now, in some states and other states that have what's called the efficient proximate cause doctrine, all right, those states would look to the overall cause and what has to be done.
All right. Let me clarify what you're saying then, just so my audience is aware. You're saying that there's concurrent causation because shingle 2 is old and that's why it's not repairable. So wear and tear is concurrent in that. And since wear and tear is excluded, they're not going to pay for that. Is that right?
That shingle in your right hand there on the left that I'm looking at was not damaged in the hail event.
Not damaged in the hail.
Right. The only reason
that shingle, event to make this easy,
or a wind event, was not damaged. All right. So since it was damaged, and if it was not a crappy old shingle or a defective product, which was the case in the All Saints case because it was an old hardy slate, synthetic tile. If it was not that, then that other shingle that was damaged could have been repaired without damaging that one. And so therefore the insurance company does not owe it under the concurrent causation doctrine.
Assuming that a repair can be made without damaging this, then it wouldn't be owed. If a repair can't be made, it's impossible, no matter what, to not damage this one. Would it be owed?
I mean, it's a very close call because I'm not going to commit to it because it depends upon the situation with the tile or the shingle. All right. So I understand the argument you're making. Okay. And in some scenarios that you just have to tear it out or you have to do something. Then in some circumstances yes, there would be coverage. But that other one, on the other hand, if it can't be done, as you're saying, because it's an old crappy shingle and when you touch it, it falls apart, that's not the insurance company's problem.
So if it's functioning, though, it's shedding water currently, it's providing its function up until the point that this one gets replaced, then the cause of loss isn't necessarily wear and tear. There might be concurrent causation that age is related, but the cause of loss isn't necessarily wear and tear. It would continue functioning if not but for this repair.
Yeah, I understand the but-for analysis, and that gets us into the efficient proximate cause states. But in Texas, right, if that
it allows you to identify what the concurrent causes are too. It's definitely a test for the others. What if this component? We are going down a rabbit hole. This is my last question on this. I'm sorry. What if this component cannot be replaced with anything that is compatible with the rest of the roof?
Yeah, so we could talk a lot about matching, and matching is different. States have different matching requirements. In Texas, we don't have any real clear matching law, and I think it's because we have concurrent causation. So I do agree. I do agree that there is a component of fairness that should be addressed in the claim process to ensure that someone has a reasonably decent looking roof in that situation. Now, if you put something up there that
I was talking about compatibility concerns, not necessarily.
Compatibility is a legitimate issue. Obviously, if they don't fit, right, and there's no way to make them fit, that's an issue. I get that. The problem
that the manufacturer would allow anyway, right?
Well, I'm talking as a lawyer because I know the abuses that are going on. There's 6 shingles on a 10,000 square foot roof, and the argument is that the whole roof has to be replaced because you can't replace those 6 shingles. All right, so I got to be vague because those are the abuses that I see coming in. Okay, in a perfect world, if we've got a whole bunch of shingles that are bad and they can't be matched because there's no conforming shingles, then that certainly is a consideration. But the abuses unfortunately drive the dialogue, and you and I both know if it's a shingle case situation, we can remove some shingles from the back and put those in and just replace one area somewhere. So there's lots of different things we can do. It
depends on the material. In fact, no shingles are allowed unless it's clay or cement tile or slate. Those are the only materials that are allowed to be reinstalled. But we'll have to get off this topic because we'll stay on this for a day and a half for sure.
Hey, I want to say this, Matt. When it comes to scope, if you're an attorney out there, defense or plaintiff's attorney, and you're dealing with opposing counsel, get a memo. I don't even care if it's an email. Yes, we're going to appraisal over the roof. There shouldn't be any windows in here. And what I've done is we've agreed to that. Yes, we're going over the roof. However, there was a dispute over the interior damages, and we still litigated the interior, but the roof was, taken out of the equation when it comes to a dispute. So you can get unique with these situations, and I do it all the time. I like to work with opposing counsel. I like to make these in writing. There is clarification, and everybody else should be doing that too. I just believe. So you can.
I appreciate you saying that. That's important. Yeah, we've got an appraisal protocol form that we use, and we put questions in there, the exact issues as to what the appraisal panel is going to address. Yeah, because I want closure from appraisal. I got no desire to litigate for 3 more years over what the award meant. That's not good for anybody. Yeah. So I appreciate you saying that.
Yeah.
I'm reading through some of the questions that we have. Got a lot of questions, so I apologize to my audience. There's no way I'm going to be able to put all of these up, so I'm being a little bit choosy, and it's going along with how the conversation is progressing so far. Is trying not to go backwards. There's a lot of comments instead of questions too. Insureds should be able to pay half of premium. No, that doesn't even make sense. All right, I like this comment. So far, what I'm understanding is ambiguity in definitions, at least for Texas, is the ultimate cause for the argument and claims. I've had this opinion for a while. Ambiguity of terms causes a lot of issues because a lot of times we're using terms that are jargon, and it means something different. How do you feel about what would you say if an insurance company were to try to actually have a 10-page definition section where they defined all the weird terms that we're always talking about?
Yeah, and it's what's interesting is the key terms in our policy: physical loss or damage. That really is the key. We cover physical loss or damage to covered property. That's it. And there's no definition of what is physical loss or damage. Now, under the courts over the years, there have been definitions established. But what happens is, the boundaries get pushed on issues, and then they go to the courts, and the courts provide us with guidance about what's covered. That's what's happening right now in COVID litigation. We are litigating tons of COVID matters around the country for business interruption coverage, and because no one ever addressed this issue before, and now the courts are addressing it, and so we're saying the same thing. We're seeing the same thing in our catastrophe claims. We're seeing lots of courts providing us guidance on what is and isn't covered, just given the broad scope of claims that are coming in. We're getting guidance now, and that's just how the process works. Yeah, do we want to try to address every single little issue that could ever arise in an insurance policy? It's going to be a long-ass policy if we did that.
But that would provide clarity. There are long-ass policies right now. I've seen a lot of them. Farmer Smart Plan is a long-ass policy. And although I definitely am not a big fan, there is a benefit to having it very clearly spelled out. But they still leave certain terms like physical loss or damage, direct physical loss, all those terms. You would think that that's the whole premise of the policy is based on that. And there are so many court cases about that terminology. They should just define that.
Yeah.
And if they were to do something like that in an appraisal clause, would you be opposed to an appraisal clause defining the term scope?
So I think the appraisal clause could easily say, instead of what it says now is that we are appraising the amount of loss. The one that I wrote for clients says we will appraise disputes as to the existence of damage, the extent of damage, and the cost to repair that damage. So let's make it clear that we are going to appraise all of those issues, and the company can put it in there or not, but let's make it clear that we're appraising those items. Now, what about a dispute as to when the damage occurred? That's another very common dispute. Do we want to appraise that? I personally don't think that's appraisable now under the broadened scope of appraisal, nor do I think it should be appraised. I think that implicates serious coverage questions that should be addressed outside the appraisal process. So I will not agree in most cases. Sometimes we have when I think that there's an appraisal panel capable of doing it fairly, but I typically will not agree to appraise when the damage occurred. Yeah, I think that is a coverage question that is beyond appraisal.
I agree 100%. Now we're going to be having meteorologist reports right and left in appraisal, and that just needs to be absent of appraisal.
Right. And that's the problem, right? We're going to have appraisers becoming meteorologists. And, do we spend $39 for a CoreLogic report, or do we spend $1,500 for a forensic meteorologist? And then we got all those issues. I mean, those are coverage questions that need to be decided by a court or a jury if we end up in that position.
I don't know if I've ever had a forensic meteorologist involved in any of my claims, no matter the size. They just hire an engineer generally and have them make commentary about weather instead, even without the competency for it, which is always interesting.
And we get that on both sides. I mean, there are guys on the policyholder side who are always offering opinions on when the damage occurred and how big the hail is. And I know there's some people on my side, but that's okay when we're trying to get to the truth and there's no dispute, right?
I'm okay with opinions. Let me ask you this though: appraisal is for differences of amount of loss, and so we have something in place if we have a dispute over the amount of loss. But if that doesn't include coverages and causation and things, what if we have a dispute over those things? What can be done?
Yeah, so there's two options. One, you can appraise the amount of loss, get the dollar value, and then go litigate the coverage questions after. That's option A. And we see that. Or option B, saying, you know what, it's dumb to spend 18 months appraising and then going and litigating everything else. Let's just litigate it all. So, for example, the very common scenario right now, which is exactly what you're talking about, is the issue of metal roofs and whether dents to metal roofs are physical loss or damage and covered by the policy when there's a cosmetic damage endorsement. So we're getting lots of these dumped into appraisal from the policyholder side, and we say no. All right, the appraisal panel's not going to determine the applicability of the cosmetic damage endorsement. If you want, we'll go ahead and let the appraisal panel determine what it's going to cost to replace that roof, assuming there's coverage. That's fine. So you can figure out in the appraisal that it's going to cost $180,000 to replace the roof, but then I got to go litigate the issue of whether it is physical loss or damage given the cosmetic damage endorsement.
I think that's a solid point. You clarified it even more for me just then on why coverages are not appraisable. Because if you are asking appraisers to determine coverage, then you're asking appraisers to interpret the policy.
And they become engineers. And they become engineers in causation. So they're meteorologists, they're engineers, and now they're PAs that are interpreting policy language. So, it shouldn't happen that way. I agree.
And that's why I was limited to amount of loss. That's why initially appraisal was only when you had a dispute as to the cost of repair and agreed amount of damage. That's easy. That was just a numbers issue, right? Is it going to be $12 a square foot or 15? And you just sort it out. Now, whenever we're appraising the existence or extent of damage, you have to bleed into engineering issues and coverage interpretation issues. It just happens.
If you were going to define the term amount of loss outside of the appraisal clause, you would probably define it to mean all of the coverages and scope and everything being repaired to bring you back to pre-loss, or if it's RCB, to replace with reasonable and necessary replacement cost benefits. The amount of loss is the RCB value of the damages. But they don't define it for that clause specifically. They don't define it at all. So it's a very broad term. It makes sense that there's some confusion on this.
And all I want is clarity. All right. Yeah. And we can clarify three ways. We can clarify through legislative statute, where we define what's appraisable and not. I don't want to do that. Appraisal is a creature of contract. We should try not to legislate appraisal if we can avoid it. The second way is that we can address it through the policy forms, right, which is good, which is why we're seeing carriers go to broader appraisal language to try to address better some of these issues. Or number three, we just reach agreement. Again, I come back to that. And I'm glad, the agreement here is that there's nothing wrong with an appraisal protocol. Let's get clarity so Mrs. Smith can get her roof put on quicker.
From an outside perspective, it's easy to say, let's just come to an agreement. There are PAs that try. I know and there are PAs that don't. And there are policyholders that just want their day in court. And there seems to be carriers that want to do the same thing. But we ask for clarity a lot of times on a lot of things, and we don't get it. We don't get it because they don't want to define something that isn't already defined in the policy and leave themselves up to precedent or the ability to say, well, you defined it this way for this person.
Matthew, let me just stop you there because this is an important point. I represent large commercial insurance companies. Okay, almost all of my clients are commercial insurers, and we have big losses. All right, I understand. I hear a lot of complaints from contractors and PAs who reach out to me about the large national homeowners insurers, and I'm hearing about it's exactly what you're talking about now. And I think they have less flexibility because they are concerned about nationwide procedures and uniformity and stuff. I get that. And I hear those complaints and I'm sympathetic to them. So in my world where we have sophisticated commercial insurers and flexibility, it's easier for me to do what I'm talking about there. I recognize the frustrations when people are dealing with the big residential insurers.
I've had the same experience with the large loss side. In fact, they come to mind faster for my claims, to be frank. But for simple things. But the dollar amounts are so huge that we're talking about. I always imagined that their defense counsel is keeping them from being able to do things like define a simple term so that we can understand what the policy is supposed to mean in certain sections. And that makes sense. It could have long-term consequences for the carrier. But that then leads to a position where the policyholder has to pay quite a bit of money out of pocket just to gain coverages. Because
but you don't have to go down the rabbit hole of defining physical loss or damage. All you got to say is that a panel, you're going to determine the existence and extent of damage to this roof. We're going to agree that that's part of the appraisal process. And if the parties agree to do that, that's fine. You don't have to define the terms physical loss or damage in your appraisal protocol. All right, let them use their best judgment. That's why appraisal's there, and be bound by it.
Sure. Remington, I know you're about to say exactly what I was about to say. Go for it.
No, what's that? I like how Steve in this new, potential appraisal clause language that you're presenting to your clients, where you have extent of damages. I think that's fair, in a sense, because if somebody just misses some damage on one slope, you get your third parties out there, your two appraisers to go look and take a double look. Hey, yes, this roof was damaged by a hurricane. You guys go determine the proper way to repair those damages and the extent of the damages from the damaged, from the damaged roof system, so to speak. I like how that term is in there. I think it's fair term. Matt, what were you going to say?
I thought you were going to tell the story about the appraisal memo on one that we had together. Having an appraisal memo to set aside specifically what's going to be performed at appraisal is definitely very useful. It may require the use of an attorney to do so if it's really getting into those kind of nitty-gritty issues, which means you might end up having to pay an attorney to do so. I know that's part of some of the new language that you had written is that's necessary.
Look, I've got a standard appraisal protocol that there's no magic to it. Send me an email at sbadger@zellaw.com and I'll send it to anybody. And they'll see how simple it is, that it just lays out some things to make sure it's fair to both sides. And then the parties can fill in one section that says what the issues are that are being addressed by the panel. It's real simple. It doesn't have to be hard. A PA or a contractor, two smart appraisers, anybody can can do this. It doesn't require legal analysis on this. And I'll send it to anyone who wants to look at it.
So maybe, but even I'm a little bit confused during our own conversation right here. When we're talking about scope of damages, if we agree that some roofing components were damaged, but other roofing components may need to be replaced that weren't directly immediately damaged by that storm, but would still be part of direct physical loss, is that a difference of scope that isn't appraisable?
So that is an issue that if the parties agree, though, that the panel gets to decide the existence and extent of damage, they could agree to address that issue.
And if the panels don't agree on that, what is appraisable in the state of Texas right now? Would the scope of repairs be appraisable in Texas right now?
Yeah. So let's talk about that scenario where you've got, the shingle or the hardy slate tile next to the damaged one has to be replaced because when they're working on the damaged one, it comes apart. All right. If that appraisal panel awards a full replacement without an appraisal protocol, they just award a full replacement. All right. Then that ends up on my desk. All right. I would have the right to raise the concurrent causation issue and say this is a coverage question that was outside the scope of the appraisal process. They awarded these other slate tiles even though they weren't damaged, and I'm going to fight that in litigation. But if we reached agreement in advance, we can do that to allow the panel to address those issues.
And
Matt, this is a difficult issue. We've honed into one of the more difficult issues, which is not the ordinary situation, but it does come up. I'd rather talk about the 90% of the appraisals where the issue is simply, are there hail dents here that require total replacement of these shingles or not? Those are the ones we should really focus on, getting in a protocol or an agreement that we're going to address that.
The title of this was The Future of Appraisal, and this issue is being challenged so very much in so many states. Texas is one of those states that's not as challenged as often. I would argue the causation issue as well in a lot of these scenarios, just because of the steps required to make a repair would tend to cause damage to a sound material anyway in many cases. So applying concurrent causation doctrine when the primary cause wouldn't be necessarily wear and tear anyway. But that would be something that would end up being challenged and would have to be argued out possibly. So having an appraisal memo up front that discusses this would be an advantage to both sides, as long as that isn't really a disputed issue. If that's a disputed issue, then that becomes something that is just going to be an argument down the road. At least you'll know it by attempting to make an appraisal memo or some kind of an agreement up front where your issues are going to be, if it does become a full replacement type scenario.
Yeah, and look, what else the panel could do is the panel could acknowledge that issue exists and say, here is our award for replacement of just the damaged tiles. And here is our award for replacement of the entire roof. And now you guys go sort out the coverage issue of whether or not the insurance company owes for just repair or replacement. And we've done that. We've told panels to give us both numbers and let us go address the coverage issue later. And we're knowing that the two values have been determined.
So it could be argued that the cost of repair would be the full replacement, though.
They could argue that to the court.
Segregating out that one material when it's integrated into this system, and to remove that from the system is violating the system as a whole. We keep using roofs. I'm going to keep going with the roof for the hell of it. As a scope of repair, even in the policy, they'll pay to repair or replace whichever is cheaper, basically. Well, the cost of repair includes what's reasonably necessary required to make that repair, which would be anything else that would be a component of that.
Well, if you're claiming a roof is always a single component and can never be repaired, you're not going to win that argument with us. I mean, we repair roofs all the time. Yeah, I mean, roofs can be repaired, and they're just as good as they were before.
Ooh.
Matt, you're talking to attorneys. It's a case-by-case situation, all right? we all know every roof in the world is different from every other roof. where it's
Sure.
at in the country.
And I admit that. Sure, there are some roofs that cannot be
Yeah.
repaired. Yeah, and then we argue about the reason. Yeah,
I mean,
but,
I could argue that every roof is repairable depending on how many materials end up getting replaced. If you're leaving one material behind, it's still a repair, but it's still. I could argue that. I could also argue that if you're going strictly to code, you'd have to throw reasonability out the window for me to say that no roof is repairable. But I would definitely be careful with making statements like it was as good as it was before. Just because that would be.
well,
it
look,
could
I
probably
will
be
admit that
debunked.
my client owes to put the insured back in the same position he was before.
Unless
I
it's
get that.
replacement cost, right?
We'll replace the damage, not the entire roof. If only a portion of the roof was damaged, and it can be repaired consistent with code requirements, and the roof is in the same condition it was before the loss after the repair, that's all I owe. Now, if there's some reason that it cannot be repaired or code requires a full replacement, well, then we'll evaluate that. And if that's owed, if that's necessary, then that would be obviously something we would owe them. And as Remington says, it is case by case, but I'm just nervous about a statement that every roof has to be replaced in its entirety.
Yeah.
I'm not making that statement.
Okay.
Let me finish up, Matt, and then I want to go to the next topic in this appraisal book.
Get us to the next topic.
Okay, here's the next topic. We haven't talked about a fraud in appraisal, and that's big. When can appraisal awards be overturned and so forth? Steve, I want to get your 2 cents on this.
Yeah. So let's be real clear. There's two different issues here. There's difference of opinion, and then there's outright fraud. Okay. We're always going to have difference of opinion. So a difference of opinion is to be expected. All right. So I'm not going to run off and claim fraud when there is a legitimate difference in opinion. However, there is a limit to that. So when someone comes in with a position that is a material misrepresentation as to the damage that's there, and there's no basis for it, that is fraud. And if you're alluding to the two recent matters where I sued appraisers and umpires and insureds in the appraisal process for fraud, in those scenarios, I did not believe there was any legitimate basis for the position they were taking, and they were materially misrepresenting the scope of damage at those properties. And that's why I took the act, which I'd never taken before. We've had thousands of appraisals in my office. But in those two, that's why I took the act of the step of claiming that the conduct was fraudulent. But it's rare. It's very rare. Okay. I've not done it since. And I had a lot of people call me, Badger, this is fraud. I'm like, no, it's a difference of opinion. All right. Is it a bullshit opinion that the guy's putting out there? Yeah, but it's not actionable fraud. Yeah.
There you go.
We like talking about bullshit here.
I mean, Remington, what do you think about it? Don't you think is that a fair analysis of when it is fraud or versus a legitimate dispute?
I agree. I think there is a clear-cut difference between fraud and just completely misrepresenting damages versus somebody's opinion as to what damage is and what's not. I think there is a clear cut. And Steve, I try to be as fair as possible when I look at these issues and matters, whether it's appraisal or coverage or whatever it might be. I try to put myself in the defense counsel's shoes and look at these. I truly do. And you can ask Matt that. I mean, me and Matt have had thousands and thousands of minutes of conversations about all of these topics, but I think that is fair. And when there is fraud, involved in there should be no fraud involved in any insurance claim, especially appraisal and so forth. And it should be kicked out, and usually that's the only type of action that will overturn an appraisal award, unless just the award itself is deliberately outside the scope of like a memo, appraisal memo. But when there's some actions that are taking advantage of the appraisal process and it's fraudulently taken, then there definitely needs to be some actions and overturned on both sides, whether side it is.
Yeah, I get companies call me all the time. They say, we got this appraisal award. It's outrageous. I'll say, okay, let's go through the 3 steps of whether I can set it aside. One was there fraud, accident, or mistake, basically, right? And then accident or mistake's hard to prove. So basically, is there fraud? That's number 1. Number 2, did the appraisal panel exceed their authority? Did they go way beyond what they're allowed to do and address a pure coverage question or something like that? Or number 3, is there some evidence of bias of the appraiser or the umpire that makes it unfair, where you can say that it wasn't a fair process? And I go through those 3, and if they can't give me any good evidence of those 3, then I'm sorry, you don't like it, but you got to pay it. Yeah, I mean, that's it. That's the analysis, and that's what they're stuck with. So that's what we do. The big one that got all the attention. The appraisal was in litigation for 18 months, and the insured's expert in federal court litigation said the damages were $11 million. Okay, the insured's own expert filed reports in federal court that said the damages were $11 million. We measured at 1. And then the appraiser for the insured came in, and the umpire agreed that the damage was $56 million. Okay, so was the insured's own expert in federal court litigation that incompetent that they got it wrong by a multiple of that many in litigation? So that was an extreme example. And that's why in that one case, that first one, I took that step. But I get a lot of calls, where the number goes up some. And, the example I gave earlier I wanted to talk about was new damage components. That really pisses me off. Okay, when new damage components get added to appraisal for the first time, and we just stop the appraisal and say, we're not going to appraise it. You've added the windows, you've added the trampoline. All right, that was not part of the claim. You're just trumping it up in appraisal now. So we're going to stop the appraisal, and you're going to give us 60 days to adjust those claim components. All right, and then if there's a dispute as to those claim components after those 60 days, then we will come back and appraise those. And you know what happens most of the time when I do that? They say, okay, never mind. We won't include it in the claim. All right, because they were just trying to get a higher number to get leverage with the umpire. Now, if they legitimately believe it's damaged, then great. They should give me 60 days to adjust that claim component.
I would love for some stuff to happen in 60 days. Remington, what do you think? That'd be nice.
Yeah, me too, man. Me too.
Yeah, we need some time frames in Georgia. You mentioned the word bias, and I know that was something that I wanted to talk to you a little bit about. Robbie brought up a good question. What if one carrier appraiser, doesn't come in with a position, just stands on the carrier's estimate? Do you think that might be bias?
I don't think it's bias, but I don't think it's good form either. All right, I think the appraiser's duty is to come in and develop its own measure of the amount of loss. Yeah. Now that appraiser may say that I agree with the carrier's estimate. All right. And I mean, I see that from the other side. I see appraisers from the other side come in all the time and with the same number or a higher number. And that's okay if they've conducted an independent analysis and they've said, you know what, I've looked at it and I think this Xactimate number from the carrier is right. Right? I don't think there's anything wrong with that if they've conducted an independent analysis. But if they come in and say, and I read on some of the forums, this guy came in and said he's not allowed to give any number other than what the adjustment number is. Yeah, that's wrong. Okay? Insurance company appraisers should not do that because
what can someone do about a situation like that?
I think you paper the file. That's it. This is what I tell my appraisers to do whenever we're saying things that we don't think is right. They just have to paper the file, make it real clear that they're contacting the umpire, complaining about what's happening, sending emails to the other appraiser, papering the file to make it clear. And then if something outrageous happens in the appraisal award, then there is a history of, hey, I've raised this issue during the process. Yeah, and it will just have to be addressed. But
what can a policyholder do?
No appraiser should just flat out agree without an analysis with whoever hired him. That's wrong.
What can a policyholder do if they find themselves in a position where opposing appraiser is being told they can't write for more than a certain amount?
Yeah, they should contact the insurance company, send them an email and saying, my appraiser has told me that your appraiser is limited
to what he can write. Someone's controlling what he's doing or what she is doing. And they should document that with the insurance company, because that is wrong. I agree. The insurance company should not dictate what the appraiser can or cannot do with respect to a number. That's wrong. I agree.
You've done a lot of debates on stage with people in our industry. Is there anybody that you would prefer to punch in the face more than someone else?
Oh, absolutely. Yeah, there's a short list of people I'd prefer to punch in the face, but I won't, because it's just a job. You know, we're out there just working, trying to do the best thing for our clients. So I get really frustrated sometimes, and then I just take a deep breath and move on. You know, and you ought to see the stuff that, you know, the attacks that I deal with. I mean, guys, at times I've had to, you know, lock our doors down at my law firm because of threats that have been made against me. I'm like, come on, guys. You know, this is just their insurance claims. And so, yeah, are there some people I don't get along with and they bother me? Sure. But am I ever going to go ape shit on them? No. All right. That's just silly.
But when you're dreaming, you totally do that, right?
There's a few that yeah, you know, and I suspect I'm that person to some others. All right, that's okay.
Probably.
I mean, look, that's my job, right? I represent insurance companies in disputed, ugly insurance claims. No insurance company calls me up and says, hey, we're really getting along with this public adjuster. We want to pay you just to be on the sidelines and watch this great claim get resolved. Right? I don't get hired in those. I get hired in all the ugly ones. And something you hear me on stage often say is that I got to be careful not to be Don Quixote. And, you know, I'm tilting at windmills thinking everybody on the other side is bad. And, you know, I've had some things I've posted on LinkedIn the past couple of days about some public adjuster abuses, but I qualify them as saying there's a few bad apples that are creating problems. I 100% believe there's a role for the public adjuster in the claim process. I will never discount that.
Since you brought it up.
All right, I'm going to listen. Talk loud because I'm going to walk over and grab a beer.
Yeah, go grab your beer. Do you think that public adjusters are necessary to gain claim benefits at times?
Oh, sure.
Yes.
Sure. Absolutely.
Let me say this real quick. We talked earlier on in this segment about why, hey, there's a lot more appraisals now than there was 10 years ago, 15 years ago. And I think it's because of public adjusters getting into the field and telling policyholders that they have another option and to pursue appraisal.
Yes.
Because a regular homeowner would have zero idea about appraisal. So I just want to say that, and that's a benefit under the policy to get a claim resolved. So I'll just leave it at that.
No, and that's a great point. But what's also interesting is we're having a lot of appraisal demands coming from lawyers.
Yeah.
Lawyers who are still charging a full 1/3 or 40% contingency fee and dumping matters in appraisal. That's wrong. Okay. A lawyer should not sign up Mrs. Smith on a 40% contingency fee and dump the matter in appraisal. There's a lawyer in Houston doing it on a 45% contingency fee. That's outrageous and wrong. But look, back to the basic question. Of course, there's a role for public adjusters in the claims process. All right. If you've got a disputed claim, public adjuster can help. If you've got a complicated claim where the insured doesn't have the time or the ability to quantify it, public adjuster can help. You bet. Now, on the flip side, I wonder why public adjusters take a percentage of undisputed dollars. There's often a question about, well, why are they taking a fee on undisputed dollars? That is preventing Mrs. Smith from ever being made whole, right? Because she's only got 90.
I'm not aware of a state that they're allowed to do that.
Oh, sure. They can sign up in Texas and take 10% of undisputed dollars. Happens all the time. In most states, there's nothing prevents a PA from coming in on a let's say you got a total loss fire claim. And the insurance company says, we're going to pay the entire policy limits right now. And public adjusters take 10% of that routinely. Yeah.
Okay.
It happens.
I'm familiar with a few states just because of being involved with Well, Georgia very well, just because of GAPIA and negotiating some of the language as a president of GAPIA. But I don't think the majority of PAs probably do that. But at least in Georgia, public adjuster can only charge their fee on funds that were collected once that contract had been started. I suppose it's possible they could collect it after it's already been agreed to, but hasn't been collected.
That still might be undisputed, though, Matt.
That's right.
Yeah, it still might be undisputed. I'm just leaving that as a comment.
I had to work that out verbally to see that. Yeah, fair enough.
I mean, we have a lot of initial notice of claims come in from PAs.
Sure. I got one question for you. I've asked other attorneys, and this will be the last question. Do you think that bad faith is insurance fraud?
No.
Can you explain the difference?
Sure. Insurance fraud is an intentional misrepresentation or some type of intentional act. All right. That's fraud. Fraud has an intent component. All right. Bad faith can be a breach of the duty of good faith and fair dealing. They just didn't behave well enough to their client. It's more of a negligence type standard. All right. They just didn't do the right thing. So can an insurance company commit bad faith without committing intentional acts? Absolutely. All right. They just did not do things very well. All right. They did not honor their duty of good faith and fair dealing to their client by delaying or not hiring good experts. There's a number of things they can do. That's a different level than intentional fraud. And that is the intentional fraud is a higher standard. In fact, in most insurance codes, like the Texas Insurance Code, recognizes you have breaches of the insurance code for doing something wrong. And then if you do it intentionally, then there's treble damages, right? So there's two different standards. There's just not doing things right or fairly, but then the heightened standard of fraud or treble damages for statutory violations.
So if there is treble damages awarded because they determined there was intention, do you think that becomes
knowing conduct? Yeah, and that could rise to the level of fraud. And look, it's on the other side. I can turn it around on the other side also. All right.
Oh, sure.
There's a lot
it's turned around on us a lot.
It's
going the other way has been a chore. Just convincing departments of insurance, attorneys general, that there is such a thing as insurance carrier fraud.
And I admire and I respect what the APA is doing. Okay, Doug and those guys, I admire it. I've supported it. I donated to one of the events they had in Dallas. I will support going after any insurance company who commits actual fraud. All right, but I want to make sure that the APA message is not diluted by a bunch of contractors and PAs who are threatening us with APA enforcement when we just have an honest disagreement as to a claim. All right. And I get that. I see the emails that are being sent to my clients. I'm reporting you to the APA. No, that's not the APA's purpose when we have a disagreement as to the existence or scope of damage. All right. So look, no one.
Might as well say, I'm going to tell my mom.
Right. No one should commit fraud. No one should commit fraud on either side. Okay.
Obviously.
My client should pay claims fully, fairly, and quickly. All right. They should do that. Conversely, on the other side, people should not try to win the storm on every single claim by jacking up a $100,000 roof to $250,000. Okay. And I'll anyway.
And Matt, here's a difference. Just one scenario: complete fraud versus bad faith. Let's say a claim has been closed, undisputed damages, and the insurance carrier takes 18 months to get the payment to them. That's a difference between bad faith and fraud, and that's an exaggerated scenario. But it's where they didn't do maybe what they should have in a timely manner and so forth. So just because there's bad faith doesn't mean there's fraud. Now, every time there's fraud, there's probably bad faith. but
Yeah.
not the
Not a
difference.
mutually
That makes
exclusive
sense.
thing.
Yeah.
I feel like that line is different from some states. Though fraud is a federal thing, is it not? Or is
Can
there-
be. I mean, it could be. There's state law fraud. There's federal fraud.
I mean, Remington and I had this discussion many times where every contractor and PA under the sun thinks every claim that they have has bad faith.
Mhm.
So I'm sure that we're going to have the exact same scenario thinking about everything being fraud, but there is that higher standard to be able to have enough evidence to prove that there was the intentional act. But if treble damages are a way to start looking at that, that's an interesting thought. I appreciate that comment. Steve, it's been a pleasure. You often put yourself in positions of this, where it could go very rough for you. I like that about you. You're willing to put your neck out. So
Look, I appreciate it. I think dialogue is good. All right. And every time I speak, I always just say, let's be nice. Okay. Let's be nice and try to get to a fair result. And that's why if we can talk about issues, and I'll say it again, sbadger@zellaw.com. I every night at the end of the evening, I'll sit down with a glass or a bottle of wine, and I'll answer 30 or 40 emails from people on both sides of the industry about various issues, because I think dialogue is good. We should talk through issues. I mean, I've gotten calls from PAs and contractors about my clients, cases I'm not even involved with. And they'll say, hey, Badger, this doesn't sound fair. And I'll look at it and I'll call my client up and say, you ought to pay this. Or I'll say, no, the contractor's wrong. So, yeah, we ought to work together. But if someone's going to try to rip off one of my clients, I'm going to come after them.
So,
There you go.
to be clear, you're willing to take emails from contractors, PAs, policyholders with complaints about your client. And
I will read them. But it's hard to address specific issues often. Sure. But if someone says, hey, Badger, don't you represent so-and-so? I got this situation. I'll look at it. Yeah. And I say, who's the adjuster? And I'll often call the adjuster and say, hey, what's the story here? And often the adjuster will have a very different story that I'm hearing from the contractor. But I will do that. Now, I'm not inviting everybody to come bitch at me about every claim with my clients that's disputed. But I will get involved and look at situations because, look, I got plenty of work. I got more work than I need. So if I can help avoid issues before it ends up on my desk, everybody's better off. Yeah. I mean, all the time I work, I probably bill maybe 30% of my time because I do so much stuff like this and I'm trying to help sort out issues and I do various things. But I'm fortunate to be in that position that I can do that. And I'd like to resolve. The other thing I spend a lot of time doing is helping homeowners, ripped off by various people in the industry. And that really bothers me when I see, just like people are bothered when insurance companies don't do the right thing. I get really bothered when I see homeowners ripped off by bad contractors or public adjusters or sometimes attorneys. And my phone rings on those and I'll help those people.
Are those only people that are policyholders for your clients, though?
No, I'll represent any policyholder. I mean, not for my clients. I don't. That's not situation where my clients are necessarily involved. I mean, I handle
Texas.
Well, mostly they've been in Texas. I'm dealing with some things in Louisiana and Minnesota right now, involving a particular public adjuster. But no, mostly in Texas. There was a roofer who ripped off 110 elderly and minority homeowners for about $600,000. He just kept their insurance checks. So I filed a big mass action against the contractor on behalf of 110 homeowners who were out $560,000. And no one else would help them for their little $4,000 or $5,000 claims. Right? Remington, you know this. There's not many lawyers who are willing to help a homeowner with a $5,000 claim.
Right.
My phone rings every day because if you Google roofing contractor fraud Texas, guess whose name pops up? Yeah, mine all over it. And I get calls every week. So, look, I want claims to be resolved quickly and fairly.
There you go.
And if my clients don't do it, then there's plenty of people on the other side who are going to take them to the mat. But conversely, I'm going to take people to the mat who try to rip off my clients.
Love it. Steve, I don't know if you can see this comment by Brian, but it says, Steve, thank you for presenting your position. I understand a bit more than I did before this podcast. Mission accomplished, right?
See, isn't that great? This is why we do it. Yeah, because here's real quick, and I'll stop ranting. People send me posts that are on some of these forums. Steve Patrick's Level the Playing Field and others. I'm not members of them, but they'll send me posts from them. And I'm like, I ought to get on and just talk about some of these issues so we can all get on the same page on some of this. So maybe one day I'll create a forum that we can all go to together, not one side or the other. We can all go to and have a good dialogue. Because with dialogue, we can all do what's best for Mrs. Smith. And that's what we really need to focus on.
Let's do it. I'll be an administrator to that forum. I'll
Good.
go on that. There you go.
All right. Matt, thanks for having me. I very much appreciate it. I wish you had a beer like I do.
I wish I had one too.
Hey,
Especially for
cheers,
this.
Steve.
There you go. All right, guys. Cheers.
Take care.
Thanks again, Steve.
Have a good night. Later.
Take care.
You too.